Well, welcome back, everyone. Thank you for the lively, engaging discussion so far. I'm excited to be joining you again as your moderator. You don't remember me from panel 2, Kristine Perry, a staff attorney at the Environmental Law Institute. I'm really excited to be joined both in person and online with our group of panelists for today. They will be giving some concluding thoughts on the day, as well as looking for future directions for corporate climate litigation across the Americas. So we'd like this to be interactive, engaging. They'll give a brief reflection on the day, looking forward, and then we'll have time for questions and discussion. So I'm going to introduce all 4 panelists now and then move into their presentations. So our first panelist is Randall Abate, and he is the Assistant Dean for Environmental Law Studies at the George Washington University Law School. Prior to joining GW Law in July 2022, he held full-time law school teaching and leadership positions for 3 decades at 6 U.S. law schools. He has lectured and taught courses in more than 25 countries on 6 continents. And if you're connected on LinkedIn, you will always see him going around. But he travels quite a bit. He has published 6 books, including Climate Change and the Voiceless, Protecting Future Generations, Wildlife, and Natural Resources, and more than 40 journal articles and book chapters. He holds a BA from the University of Rochester and a JD and MSL, Environmental Law and Policy, from Vermont Law School. Thank you for being here with us.
Thank you.
Our next panelist is joining us online, and this is Dr. Maria Antonia Tigre, and she is the Director of Global Climate Change Litigation at the Sabin Center. She manages the Sabin Center's Global Climate Change Litigation database with the support of the Sabin Center's peer review network of climate litigation. She is a leading expert in the field of climate change law and climate litigation, having published dozens of articles on the topic. She also co-heads the Sabin Center and the Global Network for Human Rights and the Environment's project on climate litigation in the Global South. Her research particularly focuses on rights-based climate litigation in the Global South, and the forthcoming advisory opinions on climate change. As a member of the IUCN World Commission on Environmental Law, she actively contributes to developing and advancing environmental legal frameworks. She has authored numerous publications on regional and international environmental law, with a specific focus on environmental rights, the evolution of international environmental law, and climate litigation. Her research also encompasses the protection of the Amazon ecosystem, emphasizing the importance of regional cooperation. She completed her doctorate in political studies, SJD, at the Elizabeth Hobbs School of Law at Pace University in 2022. In 2013, she earned a dual LLM, magna cum laude, specializing in environmental law and comparative legal studies from the same institution. She obtained her LLB from the Pontificia Universidad Católica of Rio de Janeiro, Brazil. Thank you for joining us online. Our next speaker will also be joining us online, Rosalía Ibarra Sarlat. She holds a PhD in environmental law from the Alicante University from Spain, a diploma in advanced studies with recognition of research sufficiency from Alicante. She has a bachelor's degree in law from the law school at the National Autonomous University of Mexico, diploma in environmental law at the Bar Association of Madrid, Spain, and legal advisor to the Environmental Law Center, ELC, of the IUCN. She is a full-time researcher at the Institute of Legal Research at the National Autonomous University of Mexico. She is a professor of environmental law in the postgraduate law school at the same school and coordinator of the seminar Climate Change Law and Governance at the National Autonomous University of Mexico. She is also a visiting researcher at the Center for Environmental Law Studies in Tarragona at Rovira Virgil University. She's a member of the National Systems of Researcher and a member of the Mexican Network of Scientists by Climate. So thank you very much for joining us. And our final speaker today is Maria Juliana Pedraza, and she is a bilingual attorney dedicated to delivering exceptional legal services and making positive contributions to society and beyond. She holds a Master's of Laws with a specialization in international legal studies from American University, Washington College of Law, where she is honored with the Outstanding Graduate Award from the LLM class. Prior to that, she pursued specialization in business transaction law and relations at Universidad Externado de Colombia, following her bachelor's degree from Universidad Autónoma de Bucaramanga. Her work experience spans various sectors, highlighting her adaptability and proficiency in government, supporting the legal processes of regional development plans and assisting environmental and social projects. In the financial sector, offering comprehensive legal assistance and guidance on banking and financial operations, further demonstrating her adaptability and expertise. She is currently working as an associate attorney at the Interamerican Institute on Justice and Sustainability. Thank you for being here. And without further ado, I will turn it over to you, Randy.
Thank you so much, Kristine. It's great to be here. Thank you to Ivano and Michael for this invitation, and really a very impressive round of panels and topics today. And not surprisingly, there's going to be some overlap, but the idea is to reinforce and highlight in this panel what you've heard and integrate it in a way that will hopefully generate some discussion. So you heard from Jared about waves of climate litigation earlier today, and I'm calling them the lines of climate corporate accountability litigation. So I want to give you kind of my take on these different stages of where U.S. climate litigation has been, and highlight some things that you haven't heard about each of these stages and their significance for corporate accountability theories, and briefly mention some obstacles to success in these efforts. So the first, third, and fourth here are most relevant to our discussion, and you've heard a little bit about each today. I want to try to get into some pieces of what we haven't heard as much about. I include the atmospheric trust line of cases just very briefly for context as part of the evolution of these cases, even though that was against governments, the U.S. government and state governments, and not against corporations. It's still relevant to get a sense of how these theories have evolved. So you've heard about two of these cases today. So the American Electric Power case versus Connecticut, the first public nuisance case, is something that Mike Gerard described very well for you. One thing that I want to stress about that is the pivoting that happened, going from the American Electric Power case to the next two cases. So basically, American Electric Power versus Connecticut was seeking injunctive relief. And even as a hopeful and optimistic environmentalist that I am, I wasn't sure that this was the right way to get climate action in the US. This was using the court system to essentially compel a percentage reduction in these major power companies' emissions of carbon dioxide. These were the leading emitters that I think represented 25% of carbon emissions in the US at the time. And the effort was to have an injunction lowering their emissions by a certain percentage. And not surprisingly, this was dismissed in part on political question doctrine grounds, because this was perceived as something the legislature should be doing, and not doing an end run around the legislature, you know, when dad says no, ask mom kind of a thing. I mean, this is supposed to be done by the legislature. If we're talking about emissions reductions across sectors in our society, that's something that the Clean Air Act is available to do, and didn't happen there. And so this effort to get it done through the courts was a good way to convey the urgency that we need these reductions in addressing climate change effectively. But the political question doctrine dismissal of this case was disappointing in some way, but not surprising. This federal displacement theory, the idea that you've got the Clean Air Act, therefore these federal common law claims should be considered displaced. Okay, Where I was much more troubled is when this theory pivoted to not seek injunctive relief, but to seek damages. Now I was more on board. This made much more sense to me. So the first case, the Comer case, which was the case involving Hurricane Katrina victims that brought a lawsuit against corporate entities for their significant contribution to climate change, which in turn exacerbated the intensity of Hurricane Katrina that ultimately affected and displaced these plaintiffs that were seeking recovery for the losses they sustained from Hurricane Katrina. And that's not to say that these emitters caused Hurricane Katrina. They just made it worse than it might have been because of the influence of the warmer waters from the higher greenhouse gas emissions. So this actually didn't do so poorly in the courts. It was ultimately dismissed on different grounds, but ultimately it did prevail at the trial court and then went up on appeal and was ultimately dismissed on banc. But here, the fact that it was seeking damages, and this wasn't the very first case, but it was building on another case against auto manufacturers that was filed previous to this one. The idea was that damages are not necessarily the same thing as seeking injunctive relief, and therefore compensating these victims for their losses is a different thing than asking the court to issue an injunction and regulate climate change from the bench. So that case ultimately did not prevail, but it showed some promise. So when Kivalina came along, I felt much more hopeful that this might be the sweet spot. We're using this theory, and again, it is involving communities that, in this case, a Native Alaskan community that are burdened by the effects of climate change. Same kind of group of defendants, about 24 oil and gas companies significantly contributing to global climate change, making this sea level rise and coastal erosion that you see in this picture in northern Alaska more severe, life-threatening. And this was, interestingly, an opportunity to expand the standing that had been established in Massachusetts v. EPA. The idea that there, the state of Massachusetts was able to have standing because of that special solicitude reasoning. The court acknowledged that the state has standing on behalf of its citizens to sue for the loss of coastal land in the state. So here we had a federally recognized indigenous people that has a quasi-sovereign capacity, very much like what we saw in Massachusetts v. EPA. And I thought the standing theory could have extended quite appropriately to this Native Alaskan community along the same lines that it had been established in Massachusetts v. EPA. That was not the outcome. So that's one piece that I wanted to highlight here, that this case was dismissed, trial court and on appeal, on standing grounds. But perhaps most memorably about the standing decision was the idea that causation was not established. And this is what ties back to Delta's presentation and what I'm trying to learn as much as I can with my philosophy major background, trying to understand climate science. Is to call it a steep learning curve is an understatement. So the causation standard for standing is very loose. You know, this is not cause and fact. This is not proximate cause. This is fairly traceable. There must be some kind of relationship from the action or inaction of the defendant and the harm suffered, allegedly suffered by the plaintiff. And here, you can imagine the attorney for ExxonMobil standing up in court and pointing to this photo and saying, there is no way to connect that coastal erosion in northern Alaska to my client's emissions. And in 2007, that was absolutely true scientifically. Perhaps in 2025, with Delta's confirmation, we might have a different outcome on that standard anyway. That fairly traceable standard, what we know about attribution science now compared to 2007, this might have survived in terms of going to trial and not being held to be limited on causation grounds because it is such a flexible standard. So it was also dismissed on jurisdictional grounds, not surprisingly, the whole political question doctrine arguments all over again. The postscript here is another thing that I want to mention in the sense that here's how, even though this case raised so much good publicity about the need for vulnerable communities to get relief from somewhere. I mean, this was a community of 400 Native Alaskans that had a price tag of 400 million to relocate them 10 miles inland, and the federal government was not providing that money. The state of Alaska was not providing that money. So they filed this lawsuit as the last ditch attempt to get some support for their survival. They were given this essentially, death notice that they had no more than 20 years to live there without being submerged. And mind you, that was 20 years ago, and they're still there. They're still trying to, in a piecemeal way, get themselves out of harm's way. But just about a year and a half ago, because there was no action, 20 years after this failure in this lawsuit, they filed a petition before the Interamerican Human Rights Commission, along with some other indigenous communities around the US who had similarly been ignored about the need for climate adaptation and relocation assistance. And that's where we are today. I mean, you literally have to grasp at any straw if you are being disproportionately burdened by climate change impacts affecting your human rights. You just have to, resort to anything. And this reminds me of how a lot of this thinking got started with the Inuit petition way back in 2005, framing this problem as climate change, but human rights as much as it is climate change. So it's interesting how far we've come and how far we have not come when you look at 20 years of strategic climate litigation. And then you've heard a bit about what I'm calling the BP v. Baltimore line. You've heard about cases that are part of this group of cases, 38 apparently, according to Mike Gerard. I've lost count, but that's higher than I thought. Around the country, states, cities, counties suing that same set of about 24 carbon majors, whatever we're going to call them, for their contribution to what these states, cities, and counties are experiencing in terms of climate adaptation costs. They didn't cause this problem. They're having to build seawalls. They're having to engage in mitigation plans to adapt to wildfire threats. All of these things cost a lot of money, and they're seeking contribution from these large emitters to address those concerns. So the creative theories here is something that you've heard a little bit about, and that's something I want to continue to look at as these theories unfold. But it was really telling that there was so much evidence about what they knew, when they knew it, and what they did with that knowledge. And that whole evolution of climate denial science was very much part of this evidence, and it's really, really powerful. So you've heard that these are starting to get to trial. Win, lose, or draw, this is a huge success. When this information goes to trial, it's going to be transformative. And we're almost at that stage where it is so widely known that it's having a big impact on how these corporations are going to have to do their business. The postscript that I want to add to this line of cases is just a few weeks ago, the Supreme Court rejected a challenge by Republican states trying to keep these cases from going to trial. So this is very much reminiscent of what we saw with Juliana. Juliana was another case where, I mean, it was like an advanced course in civil procedure, trying to follow what the federal government was trying to do to get that case from not going to trial. I mean, procedural motions I hadn't even heard of, unprecedented efforts that the federal government engaged in to keep Juliana from going to trial. This is something I also hadn't heard of the states trying to get this kind of a case from proceeding to trial, but it failed, thankfully. So that's where we are. It's looking hopeful on that front. And this is just a summary of the information about why these cases are so strong when they get to trial. There's just really potent legal and scientific evidence at their backs to I think, do well in trial. I don't make predictions about climate litigation. I learned 20 years ago not to do that, but it's essentially about as strong a case as I've seen studying these cases for 2 decades, in terms of not having a standing concern, not having to navigate around that federal displacement barrier and so forth. So the climate washing line is something I'm going to get into more tomorrow if you're going to show up online for that discussion. But I did want to talk about how this builds on the BPV Baltimore line in the sense that it's very much about that deception and how the deception is part of the accountability in that effort to seek damages, but it's also a separate legal theory to hold them accountable about how they're communicating with the public about what their practices are all about. So there are some cases that I'll go into more detail on tomorrow, but there was a discussion earlier today about what greenwashing cases have happened, have been successful, and there's certainly a wide scope of what these cases involve. There's product cases, there's cases that talk about action or inaction. And so one product case that I wanted to just throw out there, and I say it because I'm a plant-based eater, and so I'm a big fan of oat milk companies. And there was a lawsuit against Oatly, some company I support. I don't think of them like Exxon Mobil, but they overstated the purported climate or carbon footprint benefit of drinking oat milk compared to traditional dairy. They said it was like 75% better, and it was only 50% better, and they were held accountable for that. That's misleading. And I'm all for that, you know, don't lie. It's not nice. So we're seeing this with other efforts in all aspects of what climate washing is about. So I'm going to get into this in tomorrow's discussion, but I think it's important to know that these three categories are really what we're looking at when we categorize the climate washing universe. We'll certainly be able to talk a little bit more about that tomorrow. Different theories that have been used here. And so as far as obstacles to success, I mean, these are things that we've heard about all day. I wanted to highlight a couple of things, just remedies and causation very briefly. So with remedies, one thing that really stalled the atmospheric trust line of cases, and again, I agreed with it. What the youth plaintiffs were asking the federal government to do there was create a climate recovery plan. Again, this is not something for the courts to do. This is for Congress. And so even though I fully believe that these youth plaintiffs deserve to have a climate change law that's going to protect their futures, the remedy there was a problem. It was dismissed for lack of redressability. Causation at trial is another thing to think about. I mean, if we've got cases like Kivalina getting thrown out, not even meeting the standard of causation at standing level, the causation at trial is significantly higher. So that's also something to think about in terms of barriers. And you've already heard about the slap suit concern with that, the reference to the Dakota Access Pipeline decision against Greenpeace recently. So I'll stop there. Thank you very much. Look forward to your questions.
Thank you. And now we're going to go online for Maria Antonia.
Hi, everyone. It's a big pleasure to see you. I'm really sorry that I can't be there in person. I had a childcare emergency and couldn't come. So, you know, it would have been really nice to be there and meet all of you in person and have a proper chat. But here we are. It was really interesting to hear from all the speakers today, and I'm gonna try to like talk about a couple of aspects that stood out to me with respect to South America. You know, I'm from Brazil originally, even though I've been here in the US for over 13 years at this point, and I manage our climate change litigation database at the Sabin Center. Professor Gerard mentioned it this morning, sort of how the numbers are increasing quite a lot, as well as the regional diversity. You know, coming from Brazil, I'm obviously particularly interested in cases from the Global South and trying to give visibility to cases in the Global South. So I've written quite a lot about Latin America, in particular, climate litigation and Latin American climate litigation in the Global South as well. And what's interesting, I think, to see is that, you know, there isn't too much on corporate climate litigation yet, even though there are, as was mentioned throughout the day, several sort of avenues to pursue that, and some examples of cases as well, but not a lot of decisions yet. So I think it's good to see from that perspective that everything's still sort of blossoming in a way, and there are a lot of interesting things happening around the world that could be, from a comparative perspective, replicated regionally, as well as some other topics. So I'll talk a little bit sort of about all of that. I think, similarly to the rest of the world, there are lots of cases related to environmental impact assessments and permitting procedures. And I think that sort of has been the traditional and unsexy piece of climate litigation as it developed. And these cases are usually brought against, the government bodies that are responsible for the permitting procedure, as well as in some cases corporations as well. So a lot of sort of the traditional corporate climate litigation that has happened in the region relates to these types of cases. We haven't seen yet a lot of climate washing cases, which it was just mentioned as well. And as far as I know, we haven't seen any type of sort of the ambition type cases like the Shell Milieu Defense case either. Although there are obviously conversations about that. I think Brazil has a couple of interesting examples. Daniele mentioned this morning potential cases related to climate disasters, which could certainly change the landscape of cases as well. And Brazil also has a lot of pending cases related to climate damages, which have been brought against individuals that cause deforestation in Brazil, as well as some corporations in certain cases. And I think that is really interesting to see. And I keep mentioning these cases as really really crucial examples, because there really haven't been a lot of climate damages cases around the world. So Indonesia has a very limited number of cases, and there's sort of early cases. The methodology to assess those damages is very different than what's being proposed now. The numbers are, it's a different scale from these types of cases that exist in Brazil at the moment. So I definitely think these should be studied from sort of a wider perspective, beyond Brazil. There are language limitations for sure, for scholars outside of Brazil to understand them, but I think it's really crucial to see that. And there was a whole talk about the Peruvian farmer case as well earlier today, which, even though it's a case based in Germany, it has a transnational aspect that's really interesting. And potentially could be replicated if that case is successful. A judgment is expected next week. So everyone's in 2 weeks, I think, actually on the 14th. So everyone's sort of expecting, waiting for that and to see what's happening. But I actually just heard recently that some people in Germany think it's very likely that the case will be dismissed, which I think will sort of be on the opposite end of the expectation that's been going around sort of this community. So we'll see on that. But I think the interesting piece of that is obviously we're holding companies in the global north responsible for the damages that are being caused in the global south. So there's a way to sort of address that type of north-south disparity with respect to the climate injustice aspects as well, which is really interesting. And there's a similar case in Switzerland that was brought by community of fisherwomen and from Indonesia. So it's sort of a similar type of model, but obviously testing out this theory in another jurisdiction as well. So another thing that I wanted to mention that I tried to follow as much as I could today, but I didn't hear anything on that, but maybe I missed it, but is on just transition litigation, which I think is really, starting out in around the world, sort of in like a new-ish type of climate change litigation. it's sort of like a weird animal in a way, because I think traditionally climate litigation has been defined as sort of the, categorized between the pro-climate and anti-climate cases. And I think it has become so much more complex than that initial assessment. And I think just transition litigation is a big piece of that, right? It's a big, it's a good example of like neither here nor there, right? Because just transition litigations really relates to cases that are brought by communities that are being, can be workers traditionally, but also indigenous communities, traditional communities that are being impacted by projects that relate to an energy transition, right? So these could be, solar projects or the critical minerals projects as well. And a lot of the critical minerals are found in the global south. And it's, there's this real danger that we'll sort of just replicate some of the mistakes of the past of during the fossil fuel boom of actually failing to consider all the human rights aspects that need to be observed during this energy transition as well. And losing sight of obviously we have this goal of the energy transition. We have net zero goals around the world, but really it's crucial to do this properly and not lose sight of the human rights that are being impacted by these types of projects as well. So we wrote a report, maybe it's like 2 years ago at this point, on just transition litigation in Latin America, which really sort of starts conceptualizing some of these types of cases. There are more cases now, and I think there are a lot more that are not on our radar yet. These are not often brought in as climate cases either, even though obviously climate change is a piece of that, considering how these projects are really have this overarching goal of an energy transition to reduce emissions, right? So but it's really interesting because then they're sort of comparing these types of cases, right? And these are, some are brought against the government, and several, like similarly to some of the EIA cases, are brought against corporations as well. So I think that's sort of another piece of that I, at least now, I haven't really heard a lot of yet today. And then the other type of case that I wanted to mention too is cases related to carbon markets, which we have some in Brazil, and I think in Chile we have a few examples as well. So, again, it's sort of like it's a little similar to the just transition in the sense that these are usually REDD+ projects. These are projects that are have this overarching climate goal, but again, not being done properly. So usually these claims relate to lack of free, prior, and informed consent of indigenous communities, or really just like some people mention is as sort of a new type of colonization, because they are just using the land and without the consent of the people that are actually there and protecting the forests and so forth. So that's sort of another type. There, again, an interesting example in Brazil and in Chile too. So another type of like corporate climate case that I think should be people should pay attention to as well. And then the last thing that I wanted to mention, which was mentioned earlier today too, it relates to the Interamerican Court of Human Rights advisory opinion. I've been following these processes very closely, the ITLOS advisory opinion, ICJ, and the Interamerican Court. And the Interamerican Court's request for an advisory opinion was really the only one that specifically asked about corporations. What's the responsibility of corporations with respect to the climate crisis? And that largely relates to the processes that went behind asking for these advisory opinions. For the Inter-American Court, there's a lot more flexibility. So the question is a lot, it's longer, it's more detailed, specific on a lot of issues, including, loss and damage and migration and corporate responsibility as well. So, and it's a more progressive court as well in comparison to the other ones, which are more traditional in a sense, especially the ICJ. So it's more likely that the Inter-American Court will actually address this question of corporate responsibility as well. Again, it's an advisory opinion, so there's no obligation necessarily for countries to follow what the Inter-American Court says, but traditionally it has been it has a lot of weight. So a lot of Supreme Courts in the region have mentioned the prior advisory opinions in their decisions. So and it has in some cases changed policies or influenced policies as well. So hopefully that will have a similar effect. South America has a big issue on implementation. I think it's something that bothers me quite a lot because we spend a lot of time finding climate cases and analyzing climate cases and then looking at the decisions, obviously, but then it's really hard to track what happens in the aftermath. And one of the big examples of cases, of climate cases, against the government in that case, but in Colombia, the Future Generations case, there were a lot of reports in the aftermath from the NGO that brought the case that the decision was actually not implemented. And I think until this point, it hasn't been fully implemented yet, even though there's really been years since that decision, since the court made that decision, so published that judgment. So, it's not a problem that only happens in South America, the global South in general, but also countries in the global North face similar issues, especially because really some of those decisions really take years to be implemented. They require changes of policies, and so for corporations, it's a little easier in a way to have that accountability because it's easier for the government to track that. So that's sort of the last point that I wanted to make of how crucial it is to also think carefully about the remedies that are being first requested and then granted, if that's realistic, if it's easily implemented or not, because it really can render certain decisions moot to a point, because sometimes, I think especially the cases against the government, what happens is that the government doesn't really have the capacity to implement that according to what the court has said. So I'll leave it at that for now, and I'm happy to answer questions as well. Thank you.
Yeah. Thank you very much, Maria Antonia. So now we're going to go back online to Rosalía for an intervention from you.
Hola, ¿qué tal? Buenas tardes. Los saludo con mucho gusto desde la... Hola, buenas tardes. Los saludo con mucho gusto desde la Ciudad de México. Agradezco muchísimo la invitación a Ivano y a Michelle. Para mí es un placer compartir estas reflexiones en estos temas tan interesantes. Y pues bueno, voy a hablar en español porque me siento más cómoda hablar en mi idioma, sobre todo al tratar estos temas tan técnicos. Bueno, respecto a todo lo que hemos visto en esta mañana, yo quiero enfocar sobre las visiones diferentes que se tienen en los litigios climáticos, y en especial quiero aterrizarlo al tema de derechos humanos. ¿Esto por qué? Porque es el enfoque que nosotros aplicamos en México en la litigación ambiental y climática. Nosotros, en comparación con Estados Unidos, no tenemos un caso corporativo representativo. Estamos igual que Canadá, o sea, no tenemos un litigio climático catalogado en materia corporativa, porque, pues bueno, nuestro enfoque es más en derechos humanos, donde el principal responsable es el Estado. Digamos que en esta línea nosotros entendemos y nos vinculamos con este marco jurídico de Hawái, el que se destacó, en donde el derecho constitucional a un medio ambiente limpio y saludable es la base más sólida para las reclamaciones ambientales. Y eso en México nosotros lo entendemos porque es algo que nosotros lo tenemos como un marco jurídico bastante sólido y muy fuerte. Entonces, quiero hacer este comparativo de lo que sucede en México para destacar este enfoque que para nosotros es muy relevante y que por lo visto también es replicado en el sur global. como lo comentaban los colegas, tanto de Chile, Perú, y bueno, otros casos que se han presentado en Brasil, Colombia, etcétera. Para nosotros, este enfoque de derechos humanos es primordial porque justo el Estado es el principal y obligado de respetar, proteger y garantizar los derechos humanos. Entonces, en este contexto, en México, los 22 casos que nosotros tenemos catalogados como litigio climático, que son pocos, vamos a encontrar que el demandado principalmente es el gobierno. Y lo demandamos ¿por qué? Por el incumplimiento de las obligaciones en materia de derechos humanos, especialmente por no cumplir con el derecho humano al medio ambiente sano. Y esta inobservancia está vinculada además con la legislación en materia de cambio climático y normativa energética que regula la transición a las energías renovables. ¿Quién demanda básicamente en México? Las personas físicas, la sociedad civil acompañada de ONGs, organizaciones no gubernamentales que se dedican a la defensa del medio ambiente. ¿Y cuál es el recurso que nosotros empleamos para esta defensa como un medio jurisdiccional? Es nuestro juicio de amparo. Este es un medio de control constitucional en el que además nos da la vía de acción para buscar la defensa y protección de nuestros derechos humanos reconocidos en nuestra Constitución y en los tratados internacionales. Y ahí es donde nosotros encontramos la fundamentación jurídica sólida y de base para los juicios que tenemos catalogados en litigio climático. ¿Y esto por qué? Porque tan solo en México y prácticamente sabemos que en varios países de Latinoamérica hemos desarrollado ampliamente la protección del derecho humano al medio ambiente sano. En México nosotros lo tenemos reconocido a nivel constitucional desde 1999. Y nuestras leyes reglamentarias, lo que es la Ley General de Equilibrio Ecológico y Protección al Ambiente y la Ley General de Cambio Climático, estas son reglamentarias de ese derecho humano reconocido en la Constitución, en nuestro artículo 4. Entonces ahí tenemos bastante bagaje y fundamentación jurídica, que es lo que justo se plantea en los litigios climáticos en México. Este marco nosotros lo tenemos sumamente sólido, muy amplio, en donde además se ha trabajado desde la Corte, en las Cortes mexicanas, en los tribunales, el análisis amplio del derecho humano al medio ambiente sano. Tenemos una interpretación amplia también del mismo, tenemos bastante jurisprudencia ambiental de cómo entender y aplicar este derecho, y además en México los tribunales sustentan esta interpretación amplia con lo que ha expuesto la Comisión Interamericana de Derechos Humanos, porque México, pues bueno, es estado parte de este órgano regional. Y en este sentido, en los juicios de litigio climático que se han presentado en México, ha sido sumamente relevante lo que se ha dicho en la opinión consultiva de la Comisión Interamericana de Derechos Humanos 23/17, en donde se establece la interpretación amplia de cuál tiene que ser la obligación del Estado para garantizar el derecho humano al medio ambiente sano, que en este contexto nosotros lo entendemos como un derecho que es fuertemente afectado por los impactos del cambio climático. Y por eso siempre es la guía de acción legal en nuestros litigios climáticos, que obviamente se vincula con la vulneración a otros derechos humanos, como puede ser a la vida, al agua, a la alimentación, incluso a la vivienda, si es que hablamos incluso de casos de desplazamiento climático. Entonces, para nosotros es nuestra guía de acción los derechos humanos. Además de que nosotros en México, en esta interpretación amplia, en esta jurisprudencia que se ha trabajado mucho en nuestras cortes a raíz de los casos que se han presentado, también entendemos y aplicamos esas dos vertientes del derecho humano al medio ambiente sano, como es la individual y la colectiva. Y por otro lado, también aplicamos las dos visiones, que es la antropogénica y la ecocéntrica, lo cual esto ha sido ampliamente señalado en la opinión consultiva de la Comisión Interamericana de Derechos Humanos. Pero lo que quiero destacar es que en México nosotros empezamos a interpretar esto de una manera muy, muy amplia para resolver los casos en litigio climático. La visión ecocéntrica me parece que es algo que viene muy de vanguardia, justo para aplicarse no nada más en México, sino en los litigios climáticos que se empiezan a destacar y presentar en el sur global, porque esta visión ecocéntrica que empieza a evolucionar con mucha fuerza, empieza a buscar la protección de los elementos naturales por su valor intrínseco y que en este caso, por ejemplo, contribuyen a mitigar los impactos del cambio climático, como casos que se han dado en Colombia para la protección de los páramos, por esa función que tienen para contribuir a disminuir el impacto del cambio climático. Y entonces se da la protección de estos ecosistemas por una visión de un valor intrínseco del mismo. Pero esto se vincula con la protección del derecho humano al medio ambiente sano, porque para proteger este derecho tenemos que proteger también el entorno y los elementos naturales, pero con esta visión ecocéntrica. Esto me parece que es algo que va a empezar a evolucionar con mucha fuerza y que se empieza a aplicar en los litigios climáticos, sobre todo en el sur global. Por otro lado, lo que también se discute mucho desde esta visión de enfoque de derechos humanos es la discusión de las acciones u omisiones que pueden tener los estados en la protección del derecho humano al medio ambiente sano, sobre todo alegando que estas pueden ser regresivas justo para cumplir con las obligaciones que se tienen en torno al Acuerdo de París, porque también nosotros en nuestros juicios en México, la Corte ha interpretado el Acuerdo de París como un tratado para la protección de derechos humanos y por tanto ocupa una posición supralegal en el ordenamiento jurídico. Y esta conclusión de esta naturaleza es particularmente relevante para países como el nuestro, donde los tratados en materia de derechos humanos integran el contenido justamente de esta jurisprudencia constitucional en donde México tiene que alinear su constitución con esta protección. Entonces, por eso es interesante y es importante esa visión en derechos humanos que nosotros aplicamos y en donde peleamos que incluso se aterrice este derecho, se cumpla este derecho cumpliendo principios de progresividad y no regresión. Esto frente a los actos que puede tener el gobierno al determinar una ley, al implementar un megaproyecto, al establecer un plan o una política pública que justo siempre estén alineados con los derechos humanos. Por otro lado, lo que también se discute en los litigios climáticos en México con este enfoque es la aplicación del principio pro persona. O sea, siempre también buscar que se cumpla el derecho al medio ambiente sano con esa interpretación más amplia. Y por eso comentábamos que es importante esta amplitud que se da en el sentido de que hay que atender los tratados internacionales donde México, por ejemplo, es Estado parte y donde puedan tener una interpretación que contribuya a la mayor protección de los ciudadanos. Todo esto vinculado con los litigios climáticos. Por otro lado, otro principio que nosotros también aplicamos muy fuerte es el principio de indubio pro natura, donde también siempre se tiene que resolver a favor de la naturaleza en caso de que haya alguna duda o bien, lo que se comentaba hace rato, no tengamos mucha certeza respecto a los impactos y que podamos aplicar el principio de precaución, pero ligado con el principio de indubio pro natura. Entonces, todo esto empieza a ser muy representativo en México, insisto, en esa aplicación de ese enfoque de derechos humanos donde el principal responsable va a ser el Estado, porque de hecho, si tenemos megaproyectos donde incluso, desde luego, estén vinculadas empresas, pero aquí el principal responsable va a ser el Estado porque es el que otorga las autorizaciones, es el que otorga las licencias y toda esta normativa que debería de cumplir una empresa y que el Estado tendría que revisar, tiene que tener el enfoque de derechos humanos porque la normativa ambiental en México es reglamentaria del artículo 4, que es el que nos garantiza en México el derecho humano al medio ambiente sano. Y entonces, en este contexto, tenemos varios casos, sobre todo los 22 casos que tenemos catalogados de litigio climático, tienen mucho que ver con la mitigación de emisiones. ¿Esto en qué sentido? Reclamar al Estado que ha ejecutado acciones o bien ha sido omiso en ejecutar acciones para reducir los impactos del cambio climático. Por ejemplo, tuvimos un caso en 2020 debido a que el Congreso mexicano reformó la Ley General de Cambio Climático y eliminó el Fondo para el Cambio Climático. Es decir, para dar financiamiento, ya sea con recursos públicos, privados, nacionales e internacionales, para implementar acciones ante el cambio climático, porque ese era el objeto, y el gobierno federal lo elimina. Entonces, al ser omiso en determinar algún recurso económico para las acciones, es una afectación para garantizar nuestro derecho humano al medio ambiente sano, y es una acción que es regresiva a la protección que ya teníamos. Por eso vino un litigio climático para reclamarle esa omisión al Estado. En otros casos, nos hemos movido en el litigio climático, como se ha mencionado en la mañana, creo que en la mayoría ha sido sobre el sector energético. En México no es la excepción, también tenemos la mayoría de los casos contra sector energético por acciones que no contribuyen a la transición energética. Pero, insisto, si está involucrada alguna empresa energética, aquí al que se le reclama en principio es al Estado, porque da la autorización y la licencia de actuación. Ahora, un punto que hay que tomar en cuenta es que en México los sectores que tienen que ver con emisiones de gases de efecto invernadero son empresas del Estado, o sea, como puede ser Pemex o la Comisión Federal de Energía. Entonces, al final, el demandante tiene que seguir siendo el Estado, porque es una empresa que además depende del Estado. Ahora, por otro lado, es cierto que vienen muchas empresas transnacionales a implementar proyectos en México, pero quien da las autorizaciones es el Estado. Entonces, por eso reclamamos directamente primero al Estado, porque es el que autoriza o bien se hace omiso en la violación de derechos humanos. Entonces, en este contexto tenemos varios litigios en el sector energético para reclamar al Estado, y por otro lado, también empezamos o creemos que deberían empezarse también a catalogar dentro de la rama del litigio climático los reclamos que tenemos en transición energética justa. Y esto pues se vincula mucho con justicia climática y se vincula mucho con los casos que comentaban, por ejemplo, los que se han dado en Canadá, cuando se da violaciones a los derechos humanos de derecho a la consulta, en la información previa, libre e informada para comunidades indígenas. Y es lo que también pasa en México cuando se implementa un proyecto de descarbonización, como puede ser un proyecto de parque eólico, pero donde hay mucha violación a las comunidades indígenas y no se cumple con el derecho a la consulta. Es decir, se da la descarbonización a costa de la transgresión a los derechos a la tierra y el territorio. Entonces aquí los derechos indígenas empiezan a ser muy vulnerados y además, obviamente, vienen afectaciones al derecho al medio ambiente sano, y esto es un principio que debería de cumplir el Estado, pero esto viene obviamente vinculado con las autorizaciones que se dan a estas empresas. Y bueno, solo para ir cerrando, comentar que esto es fundamental por la vulneración que se da a los derechos a la información, participación, que son también derechos humanos que tenemos reconocidos, y además México es parte del Acuerdo de Escazú, donde además tendría que trabajar fuertemente para la protección de estos derechos, y que son derechos que también empezamos a ver que empiezan a ser una fundamentación jurídica importante en la litigación climática, pero en este sector. Entonces, yo ahí lo dejo, o sea, solo para destacar el enfoque de derechos humanos que ha sido la línea principal a seguir en los casos de litigio climático en México, y que, bueno, se han replicado mucho en el sur global. Gracias.
Thank you very much, Juliana. And our final intervention for this panel, Juliana.
Thank you so much, Kristine, and thank you all the speakers. It's truly an honor to share this space with all of you. And thank you everyone for being here today after an inspiring day, still keeping up in this last session, last panel. I'm speaking to you today on behalf of the Interamerican Institute on Justice and Sustainability, where I work as an associate attorney. And I would love to give you just an overview of our work. So at IAJS, our mission is strengthening the rule of law and good governance for public and corporate environmental and social impact. And our work focuses on Latin America. So this allows us to identify some key issues, challenges, and opportunities that on the topic that bring us together today. So also I'll mention some reference to Colombia, just given my background. And so how does this connect to the conversation on climate corporate climate litigation, sorry. For us, this all comes down to the rule of law. So we have identified tools, challenges, and opportunities, but I want to highlight 3 viewpoints on this matter. So first, global commitments on climate shape us to develop, development pathways of business activity, and clearly have an implication of the legal domestic level. So we have seen developments on the ground to advance a legal framework on for corporate accountability by addressing, as earlier was mentioned, the UN principles on business and human rights, the OECD guidelines on multilateral enterprises on responsible business, also the EU CSRD, CSDDD, and also these have influenced other recent legal developments, such as the European Green Compliance Directive, US Climate Accountability Act, single-use ban plastic bans, just to mention a few. But focusing on Latin America and the Caribbean, I would like to highlight the Escazú Agreement, the relevance of accountability and dispute resolution. This by serving as a gateway for enforcement. This also aligns with the pillars 1 and 2 of the UN guiding principles on business and human rights. And this in particular, the Escazú Agreement ensures that the environmental decisions involves the public with a focus on vulnerable groups, and businesses are also required here to facilitate participation and consultation in with the guiding of principles. The second point, we all know the countries of Latin America and the Caribbean are extremely dependent on natural resources, and result as of this, result more vulnerable to these threats. And according to the World Bank, at least 16 countries of the Latin America region are developing countries and are more likely to suffer for climate change. So meanwhile, as governments and businesses continue to find ways to approach and tackle this climate change, we have been talking, and we have this great tool that is climate action and strategic litigation. So this tool for promoting climate justice at the country level and advancing corporate accountability. We have seen a rise in these legal actions, and all of this driven by scientific progress, the growing experience from similar cases, misinformation, physical and transitional risk associates also with the climate change. And in this universe of climate disputes, the trends show that existing tensions result in actions against states or against corporations. In the case of states, we have seen this for not displaying sufficient ambition on climate targets under the Paris Agreement, or not living up to these commitments. And I would like to highlight here the Amazon case. In this case, claimants were able to demonstrate that the higher deforestation rate of the Colombian Amazon will continue to increase greenhouse gas emissions. The court ordered to formulate and execute plans in a short, medium, and long term. The court also ordered to create an international pact for the life of the Colombian Amazon to support the adoption of these measures. However, the effectiveness of this decision is limited by administrative difficulties, lack of governance in the territory, continuing armed conflict in the area, illegal mining activities, and so on. So I would say this decision has marked a trend in Colombia regarding the protection of nature and environment, but still we have a long way to go and develop this. Regarding corporations, at least 86 legal proceedings are currently ongoing on major oil, gas, and coal producers. But in this one, I would like to highlight the Ecooro Minerals Corp versus República of Colombia, or Santurban case, also known. And This is also a landmark, and also this ecosystem is the source of water for my hometown, so it's really something that matters for me. In this case, the Canadian mining company claimed for compensation against Colombia because after a series of regulatory measures undertaken by the government protecting the Paramo ecosystem, because the concession was already granted and the contract was already given to the Canadian mining company. However, the constitutional decision analyzed all the legal and scientific arguments and conclude that the Ministry of Environment and all the authorities must carry out the delimitation of the moors or the Paramo with ecological criteria, seeking the deceleration of climate change, but we are still ongoing with the process. So we can keep categorizing all of these disputes, but in sum, all these emerging and present challenges in the region related to these topics are always testing those legal frameworks. As my third point, I would like to highlight the evolution of dispute resolution mechanism. One of the main emerging challenges is the need to balance investment protection with state sovereignty in line with climate commitments. Also, the rise of climate litigation highlights the urgency of responding to society demands through the justice. Sorry, I went here. I forgot to move the slides. Yeah. And given my background, as I mentioned, I would like to say and to talk about Colombia. And Colombia is not a stranger to these global tendencies. We have developed a regulatory framework, I would say strong, from the constitution, laws ratifying treaties. Recently, the ratification of the Escazú Agreement that foresees the materialization of lawsuits similar to those seen in other countries. But I would say our future directions on these cases are that claims are not focusing on compensation for climate change damages, but on the lack of public policies and environmental protections. The claims also are normally filed against public authorities rather than against the governments itself or private actors. Colombia may have to incorporate international trends on climate change. We have seen and we have around La Oroya, we are going to have soon the Peruvian farmer case, so we can highlight our pathway with these decisions. And we also are going to have always issues that change of government, armed conflict, economic needs, and intentions to increase capital using biodiversity in an unsustainable manner as a serious risk in this context. I promise I was gonna be brief because I know it's the last one, but I would just like to conclude saying that to ensure legal security for investments beyond 2030, it is essential to integrate the UN's 8R framework. Also, there are always different ways to meet climate change obligations, but a greater integration and coordination of government, communities, and private actors will always improve these procedures. And enforceability. Also, legal actions may expand beyond environmental regulations to include broader considerations of corporate responsibility. So I would like to just wrap up with these conclusions.
Thank you. So thank you so much to all four of our panelists, and I'd like to open it up to both people online, people in the room, if you have any questions, any forward-thinking questions that this panel really is looking what's next. I know we don't have a crystal ball, but we can pretend. And if there are no questions right now, I'll start one. This is for the group, but after your own experience in your own countries, in different areas of the Americas, what's the most promising either theory for these corporate cases or trend that's emerging that you think is going to show success or has the potential to be successful going forward. Maybe not tomorrow, but it could be 10 years, it can be 15 years.
Well, I think in the space of climate litigation, when you think of how long these cases are and how likely they're not going to succeed based on the stakes that are at issue and how creative the theories have to be and just how time consuming it is to navigate all the procedural hurdles. I think the climate washing line of cases is where the opportunity for most short-term success lies. I think the scope of the claims are narrower, the pathways for legal recourse are clearer and more accessible. And I think there's just more established law blazing that trail. So when you're talking about consumer protection law, there are really straightforward standards that identify where there has been a false or misleading claim. We have the Federal Trade Commission's green guides that are supposed to be updated. They were supposed to be updated last year, any day now. And we have good precedent, I think, that's evolving about what it means to hold corporate actors to a transparent, accountable kind of relationship with the public when it's about complying with climate change commitments, because the stakes are so high and it's so important to be transparent and accountable. I think certainly the EU is taking the lead on this, but there are promising developments in the US where climate washing claims are certainly gaining traction, and they're building on a long history of greenwashing and humane washing cases in the animal law context that has built a cohesive body of jurisprudence that has been more successful, I think, than a lot of these other theories that are ambitious but very difficult to succeed on.
Thank you. Anyone else from the group? Yes, Rosalía?
Gracias. Gracias. Creo que una línea donde puede empezar a evolucionar y ser efectiva es lo que tiene que ver con la normativa en debida diligencia para las empresas en materia de derechos humanos y que ya se empieza a aplicar en la Unión Europea, especialmente la norma que deriva de la ley de vigilancia en Francia. Creo que este tipo de normativa, en donde empieza a obligar también a la empresa a cumplir con derechos humanos, que en varias jurisdicciones por ahora es un contexto sobre todo más voluntario, si lo empezamos a aterrizar en cuestiones obligatorias, como lo que sucede en la ley francesa con los planes de vigilancia, creo que esto puede ser una tendencia que podría empezar a replicarse en diversos países. Y tan solo, pues bueno, por ejemplo, ahorita en México hay un caso de un parque eólico donde estuvo involucrada una empresa francesa, donde hubo violación de derechos humanos y que tiene que ver con la descarbonización, pero ya se presentó un litigio transfronterizo en Francia a raíz de esta ley donde se exige derechos humanos a la empresa y que se vincula con todos estos temas en materia de cambio climático. Entonces, creo que por ahí podría ir la visión a futuro para buscar más fundamentación jurídica, para exigir a las empresas el cumplimiento de la protección de los derechos humanos. Y otra línea que yo veo también es la normativa que se empieza a dar en la Unión Europea ante las prácticas perversas que tiene que ver con la obsolescencia programada, que también empieza a haber normativa en la Unión Europea para ir en contra de estas prácticas que al final contribuyen a la emisión de gases de efecto invernadero. Entonces me parece que es normativa que también sería vías para la protección y los derechos del consumidor, que se vincula justamente con la contaminación que se genera por estas emisiones y que contribuyen a impactos de cambio climático. Creo que son fundamentos jurídicos que pueden ser fuertes para el litigio climático en un futuro a nivel corporativo. Gracias.
Thank you. Maria Antonia?
Yeah, I think I just wanted to emphasize this issue of the transnational cases. I think that's really, it seems like there are a lot of different types of alternatives that are being brought up across the world. So Rosalía mentioned some of the French cases as well, based on the duty of vigilance law, if I'm not mistaken, that's what she was referring to, with respect to deforestation in the Amazon rainforest and certain other. So like looking at that type of corporate accountability across the whole supply chain as well, and seeing sort of all the different stages. And just because a company is not necessarily based in, you know, in a certain jurisdiction doesn't mean that it doesn't affect what's going on there. So in the case of the deforestation case in France, it was against a supermarket chain, and thinking about that responsibility for deforestation caused by meat, you know, cattle ranching and in Brazil and Colombia. So I think these types of like different legal theories are really interesting, and to see sort of which jurisdictions are more open to that, and which, you know, types of legal claims could be explored elsewhere as well.
Thank you. Juliana?
I will just leave the experts. know about
Okay. Yes, any questions in the room or online? Ivana?
If I may, I would like to know if you can make an example. I mean, Maria Antonia mentioned this, she mentioned the just transition cases that is a new sort of movement or phenomenon that we see, especially in Latin America. Do you see some particular possible cases or that in your country is happening or might happen related to just transition cases, but involving corporate actors? This is something that I would be interested to understand. Where are we in Colombia, Mexico, and of course in the US? It's a little bit more difficult because it's down really.
Yeah, I'm trying to think of a particular example. I think we do have, I think probably most are against the government, but I thought we did have a couple of, I'm not going to remember from the top of my head, but like I think in any case, I just like I would sort of conceptualizing it there. I think there might be a case in Chile, but if not, it's sort of similar to something similar, but that relates to, you know, really sort of the workers that are being affected by like say like a fossil fuel company closing down, right? Due to certain policies that are climate related. So I think like sort of that part of like you know, the just transition of the workers in that case like would be obviously, you know, according to human rights law and to workers' compensations, you know, like all of those things being considered as well. But I think in addition to that, I think like part of those EIA requirements in a permitting procedure as well for like critical minerals mining or things like that. I think that could be potentially be brought against corporations too.
Well, I would say in the case of Colombia, as Rosalía mentioned, usually it's against the government because they are the ones like given the license. So yeah, but I think and I believe the Escazú agreement will help to open maybe that line.
All right, any other comments on that? I do see, and I saw another hand. Yes, please.
Yeah, so from what you're saying and from the talks today, it seems like there'll be an increase in cases in the upcoming years that are being heard on their merits across the Americas. I'm curious, I guess my assumption is that we're gonna have a mixed bag of rulings. There'll be the good and bad that comes from that. And I'd love to hear thoughts on how we, even if there's negative rulings, kind of how we continue to build this work, how we think about kind of mixed rulings within this space. Yeah, and how, I guess, how we like push through if there's setbacks or if there's problematic precedents that get set at all in these upcoming years.
Yeah, my approach to climate litigation for 2 decades now is it's a process of losing the battles and winning the war is really what's going on, in the sense that certainly we don't want to address the climate change challenge one case at a time. We'll all be dead. So it's really about kind of raising awareness and putting together information that will subsequently mobilize something that is in a more top-down manner. So I'm really convinced that the climate justice strategic litigation that happened during the Trump 1 administration is largely responsible for the IRA passing. I mean, I was shocked that we had anything resembling climate litigation. And I think the amount of awareness that was built through all the litigation that happened in 2016 to 2020 was mobilizing a grassroots movement that was leaning on their elected representatives, and you know, that legislation just wouldn't have passed without that awareness building. So I also think there's the science and the legal theories behind the litigation ultimately helps inform how legislation should look, what it, you know, angles it should take, where some limitations might be. But in the short term, in terms of structuring those legal theories and just looking at it from a litigation perspective, I think we heard earlier today that it is dangerous to be too ambitious, because you win and then you lose. So we've seen these fantastic strategic climate litigation victories that, including in the US, Mass v. EPA, that took a decade to implement and then imploded. If it's too ambitious a victory in the court, it's going to face backlash and it may never be implemented. So we have to be very strategic about what we're looking to accomplish in the courts, because even a win could be a loss if it's too ambitious.
Other responses to this? No? All right, I think we have time for maybe one more question. Online or in person? Jared.
Sure. A lot of these, this is such a fast moving and active field, and it always feels like there's a new bit of news each day. So I'm sort of curious from each position where you all sit, what is like the next thing on your horizon, or what is one sort of thing you're waiting on, whether that's a court decision or a hearing or a report that's coming out, or sort of what is one thing that we can look forward to this year or in the coming months in this area?
I'm encouraged by the slow but steady movement of that BP v. Baltimore line of cases going to trial. I mean, I think win, lose, or draw, that's going to be a very important victory for promoting corporate climate accountability. And it's not clear what form that might take, but there's just a lot of evidence that the writing is on the wall, and I think it's going to be a very pivotal moment when there is that sense of, okay, now we're on the hook. To whatever degree we're on the hook, we've got to pivot in a way that's going to be better for the climate, because we have to, because they won't do it before they have to. So I think those cases really do have the momentum that will create some positive outcome. It's just a matter of how soon.
Anyone online like to chime in?
No.
Juliana?
Well, I would say from my point of view, and I'll be insisting on this because I'm actually working related with the BIICL agreement, and this was just a huge change for us in Colombia, and I'm just waiting to see if this is gonna lead to somewhere else, maybe encourage some other cases, or maybe corporations will gonna be now as the international trend. Maybe it's gonna be a national adopting that. So I would say I'm just waiting on how evolved this path.
Well, thank you so much to everyone on this panel, to Ivano, to Michael, to Jared, to Helene, to Sarah and Madison that have been running the back end. So I will give the word over to you, Ivano, Michael, if you'd like to close us out.
Okay, so just two words, because I know that it's very late, and I think that we have really the chance of listening to great speakers and experts. So I'm not taking more time. I just want to thank all of you, all the speakers, all the people participating in person, online. I would like to thank Michael for his support, the organization that we had together, Jared, Ellen, everybody that contributed and organized this. It was impossible to do without you, especially that we are coming on from the other side of the Atlantic. And it's really a pleasure, and it's been an honor to do this at Eli. So thank you very much, and I hope that you can follow our work. As I said at the beginning, the Global Toolbox on Corporate Climate Litigation is an ongoing project. We are just, I would say, at the beginning of it. We just starting scratching the surface, and we would like to, with your help, with the help of all the different experts in the different areas, with the judges, with the scientists, of course, the practitioners, to try and find the better way of working together in this complex but also exciting part of climate governance. So thank you very much, everyone, for contributing to this. And I look forward to meeting you again very soon. Thank you.